Good afternoon, and welcome to another episode of the Legally Balanced podcast. Today I have our special guest, Olivia Lowery. She's one of the senior attorneys here at Blood Law, and she's also my sister. So that means she's one of my favorites. So the great thing about Olivia is that she is duly licensed, which means that she's licensed in North and South Carolina. And for those of you who follow us, you know that we have offices in North and South Carolina. So she is in charge of all of our South Carolina attorneys. And today we're going to talk about the differences between custody in North Carolina versus South Carolina.
Yeah. So I've been licensed in South Carolina for almost a year now. And at first when I got licensed in South Carolina, I was really surprised at how different the law is in South Carolina versus North Carolina, especially because, obviously they're so close. We're in the Bible Belt. You would think a lot of these laws would be the same, but it's actually not. And a lot of people talk about how South Carolina is a very mothering state. And in a way, it kind of is. In South Carolina, there's a presumption that one parent should be the primary parent and then another parent should be the secondary. So it's very different from North Carolina.
Yeah, which is 50-50 mostly.
Right. And so when we go to court oftentimes...
Is that from their Court of Appeals?
It is. And it's in the statute.
So they really want one parent to have...
Right. They want one parent to be designated as primary and another designated as secondary. Even if the parties want to do a joint custody schedule, that designation is usually there. And it's interesting because our South Carolina judges technically don't have the discretion or the ability oftentimes to order a joint custody schedule unless it's something that the parties have already been operating under. So when we go in there, we're kind of stuck with, hey, one parent is going to end up being the primary parent.
What does primary mean? Like they're with them more?
Primary is partially that they're with them more, but it also means that that parent has the ability to make decisions about the children.
So they don't make them jointly?
No, not necessarily. Sometimes they do. Say we go to court, we have a temporary hearing, and the parties have already been separated, and they've decided, they're going to do something close to a 50-50 schedule. Well, when they get to court at that time, the judge can say, well, I think the status quo is working pretty well, so let's keep it that way. But otherwise, the judge is going to put a primary parent in place. Okay,
which is really different from North Carolina, as we've talked about before, which the presumption's usually 50-50, equal time with parents, and typically 50-50 with the decision making. So there are two distinctions here. So physical custody is where the kids, where they stay overnight, okay? And then legal custody is just decision making stuff. So does South Carolina... What do they call those two?
It's the same thing. We have legal and physical custody as well.
Okay, got it. So the presumption in North Carolina used to be that mothers were best, but that was basically repealed in the 80s. So, but it is case law in South Carolina.
It's not that the mother's best, but that whoever was the primary caregiver during a marriage, it's presumed that they are still the best person to be the primary parent.
Okay. So what else is different?
Let's see. Well, what is very different is the way that they handle temporary custody or even temporary hearings in general. So in North Carolina, when you go and you have a custody hearing, say it's time for a temporary custody hearing. As you know, we bring in witnesses, our clients get to get on the stand and testify. Well, it's not like that in South Carolina. When we have a temporary hearing, those hearings are on the packets. So there are certain documents that we have to bring and show the judge for those temporary hearings. That includes a proposed parenting plan, a financial declaration showing what the parties' respective finances look like. But those specific documents have to be presented to the judge. And oftentimes we go there with our clients and we hand the packet to the judge, and then we just have to sit and wait for the judge's ruling. And depending on the judge that you're...
And what goes in the packet?
So what goes in the packet is that a proposed parenting plan with whatever, schedule that you're proposing, a financial declaration stating your income and any, assets and liabilities that you have. Parties can execute affidavits saying their side of the story and, what they think is best for their children.
Do that?
Everybody does that.
Okay.
And then you can also attach any evidence that you want the judge to see. As long as it complies with the rules of evidence, it can go inside there. Like medical records, school records, anything like that. And a judge can consider it.
But they don't have to?
They do not have to.
How long does the affidavit, how many pages do you get?
You have a limit of 10 pages in the affidavit.
That's kind of scary if you think about it, guys. So judges are making decisions based on just what is in a stack of papers and not getting to hear from you.
Right.
So whereas different, North Carolina, of course, they're hearing testimony. And South Carolina, what opportunities for settlement?
Oh, we have plenty of opportunity for settlement. Okay. Now, the only downside for that is that when you have a temporary hearing request, you're going to get a court date within 30 days. And the only way that you can get beyond that time is if you submit a request to the judge and explain why that extension
Here comes the law dog lady.
And so while you have time between the initiation of the case and the temporary hearing, it's pretty quick. But that gives you the opportunity to come to a temporary resolution rather than, leaving it into the hands of the judge, who's really just going to read the stack of papers that you give them and make the decision. And now some judges let us have oral arguments and say our client's side of the story, but some judges don't. For the temporary. Okay. Right. And some don't.
So where do you like practicing better? North or South Carolina?
South Carolina.
Why do you like it better?
A lot of it is actually not based on the laws, but about how the attorneys in the South Carolina bar treat each other. I find that they're a lot more respectful and willing to help you. I've had a lot of attorneys who I've just been able to go and ask them about questions and pick their brains about things. Even though they're on the other side of a case, they're still willing to talk and explain, this is why this happened. This is why this happened. And I don't feel that type of, camaraderie in North Carolina. And I know that's something that we've talked about. And there's even, CLEs being issued in North Carolina, how to deal with a opposing counsel who's a bully. I have not dealt with that in South Carolina one bit. Yeah. And it's crazy to me because we're not that far away.
Yeah, we've talked about, we talk about that at the office a lot. One of the hardest part about practicing family law is dealing with opposing counsel. I don't know what it is like. And it's, it's a lot of women in the law now. And it's just, it's hard. I mean, right. Yeah, I don't know. I mean, I we try to give clients a heads up, like your opposing counsel is going to kind of make or break your case as far as how it goes. It's really unfortunate that it's gotten that, it's been that way my whole career, and law school's kind of like that. Don't you feel like they kind of they pit us against each other,
and they really try to work off of your competitiveness in law school, which I think is hard. It creates a toxic environment between who is supposed to be your peers. We're supposed to be part of this bar, which is supposed to be, you're surrounded by this group of attorneys who are supposed to be able to support you and give you insights on anything, but oftentimes it's not like that.
We have a guest. I did a CLE last month, and we had a guest that she's going to come on the podcast. Her name is Erin. She's an attorney, and she's real big on advocating for being kind to our colleagues, which seems so simple, something that we should do. But yeah, so it's hard to be friends with people in this business. I've tried to tell Olivia that. It's hard. It gets hard. You realize over practicing for so long. So.
Right. It's hard, but there are good ones out there. I definitely haven't really felt bullied or spoken down to or anything like that when it comes to my South Carolina cases. That's few and far between.
Do you have any North Carolina cases?
But I have in North Carolina.
Yeah, I've had to send a few emails to people.
Right. And I've practiced in 3 different areas now. I practice in Raleigh, in Charlotte, and now South Carolina. And Charlotte, I have to say, has just been the most competitive market when it comes to attorneys and the way that they treat each other. It was a shock to me, and it was a big adjustment coming to Charlotte and, experiencing that kind of thing.
I feel like this plays a role into mental health for attorneys and why we're required by the bar to do substance abuse CLEs. And, a lot of people have anxiety, depression. We're not helping ourselves. If anything, the bar should be educating us on how to treat people like humans. So what are some ways that you deal with the stress?
Unlike you, who you like to exercise when you deal with stress, I am much more of a homebody. I like to go home, sit down, and get my Kindle out and read a book. That is my stress relief.
Yeah.